Hi, and welcome to Bar Talk. We are filming today on location in Chicago's Ukrainian Village. We are privileged to be having a show on problems with joint tenancy, topics about fighting for your marriage when one spouse is not interested in getting a divorce, and some other hot topics and have you heard. Welcome to the show. Hi, ladies. How are you guys doing tonight?
Hi, great.
Good to be with you. So welcome to my office.
Thank you.
This is where
great place.
This is where I come every day, and happy to have you guys here. So I want to talk with Dana first about joint tenancy bank accounts and issues that come up often with people who have joint accounts together.
Yeah, well, something I come across in my meetings with people is that they oftentimes will put one of their children on a bank account with them because they want some help managing their affairs. Most commonly in the context where one spouse has died, and so now they rely more on a child. And so they think that by just adding their name to the bank account, they're doing everybody a favor because they can the child can help them manage their affairs. The child is going to be looking out for their best interest. Right. And I think something that people don't realize is all the problems that come up as a result of doing so.
Are you talking about like financial exploitation?
Well, that is one of the problems that can happen on the extreme side, where if your child now starts to use these funds in a way that you don't want them to, it might be difficult to get that child off of that bank account if they're unwilling to get off.
So once they're let into the bank account access, is it because of the banking rules and the agreement that they sign with the bank?
Yeah, it has to do with, if you're adding a name and they're creating an ownership interest, the bank sees them as an owner and as a joint tenant of this account, so they can access all of the funds in there at any time.
Do whatever they want.
They have every right to do so. And
now let me just ask you a quick question. I know with credit cards, they sometimes have a primary card holder and a secondary. Is it like that in banking, or are they sort of seen as having equal rights to the account?
Well, the two account holders on a bank account have the equal right to the whole of the bank account when you're holding that in joint tenancy. I mean, you can have a bank account where you own it, but maybe you name someone a custodian, so you own the interest in it, but that custodian then has the right and responsibility to use those funds for your benefit.
Is that
so
the
sometimes people do that with children. They have a bank account where the value belongs to the child, but there's a custodian named, or similar to a trustee concept, and then that person has a legal responsibility. But when you just add a person's name on that bank account, you run into these problems like you were bringing up. If this child starts doing something you don't like and you now want to take their name off, it's not so simple, especially if the child or person doesn't want to come off. I mean, you might have to file a lawsuit.
Would it like be a partition
to get your money back? Well, a lot of times banks get very nervous about these sorts of situations, so they will freeze the account and they don't want to do anything without a court order. So now you're filing a lawsuit and you're trying to make your claim. There's always a defense that this was a gift. The child could say, this was a gift to me. I was under this impression, and you might have to raise those issues in a lengthy court process.
What would you recommend, though? Because sometimes parents do need the additional help. So
yeah,
is there
absolutely.
Any middle
and the
ground?
answer to this is the purpose of a power of attorney for financial transactions. Here it's called a power of attorney for property, and that is where you're designating someone to act on your behalf. But that's a very serious responsibility. When you name someone an agent, that agent is legally bound to act in your best interest. They cannot commingle. They have a duty of loyalty. I mean, they have responsibilities that they can be held accountable for.
Well, so Dana, I have a question for you. In the context of, you have the situation you're speaking of where you add someone as a joint tenant. What about when you make someone a signatory on the account? Is that the same thing as creating a tenancy? If you have just a signature card added, that like a partner or even a child or another family member?
It's going to come back to how that account was titled and created when you have both people there, because even when you present a power of attorney, the bank oftentimes wants to see the signature on the power of attorney, and they're going to take copies and they're going to have you sign a signature card so that they can have all their records in order. But some other things that come up that are more common is that when you're adding someone's name to that account, that could be seen as a present interest gift. And if there is a gift tax exclusion issue, because maybe there's a lot of money and now maybe someone is using that money but you're okay with it. You know, sometimes a parent puts a child on the account, the child uses a little bit of money, the parent is okay with it, but no one's really keeping track. There might be a present interest gift made, and if that is the case where it's a large sum of money, maybe a down payment for a house, you might not even realize that you could be liable for a gift tax.
Interesting. Well, it sounds like you'd have to talk to your accountant, and maybe the child would also have to have some independent legal advice.
Yeah, I think you just want to keep in mind that when you add someone's name to the bank account, there are consequences that you may not realize.
Very good advice. Well, thanks, Dana, for bringing that to our attention, and we'll be back in just a minute. Welcome back. We're going to talk with Ish about questions of whether or not one spouse is interested in a divorce can force it upon the other. Ish, tell me about it. What happens when one person's still in love, they want to stay, and they want to preserve the marriage? What does the spouse who's interested to exit the marriage, what can they do?
Well, unfortunately, whether or not you get divorced is really not your choice. And it's really sad news. A lot of people don't want to hear that. They want to think that they're in it for the long haul and they've made a commitment, so doesn't that count for anything? And the truth is under the current law, it really doesn't.
So if you have a married couple and Jim Bob says to his wife, Diane, sorry, baby, I found someone else, we're getting a divorce, she's got no right to say, but no, we're in it. There's nothing she can do legally to cause a stay, tell the judge that she hasn't done anything wrong. She's got
You bring up a really excellent point, because this goes back to how in Illinois we used to be under the fault divorce laws, but we got rid of that at least 40 years ago.
So the no-fault divorce means you can get a divorce even if it's not your fault.
Exactly. Or if no party is at fault. No one has to be at fault. We're not going to ask those questions anymore. As long as you can swear and testify to the fact that there are irreconcilable differences, that's all that we need to proceed.
Well, I hear it from the other angle, where people think that they can prevent the divorce from happening. I hear people saying, I'm not going to give you a divorce.
But the reason why you can't prevent it is because we don't require fault. And so since it is no fault, then anyone can get a divorce at any time. The only caveat I want to mention is that there is an issue when it comes to timing. So under the law, you have to be separated for a minimum of 6 months before the divorce is granted. And in theory, you really should be separated for a term of at least 2 years.
So what happens when the spouse won't move out?
Oh, it doesn't matter. You can live
just
together.
You have to live separate and apart. And so they are talking about that in terms of your behavior.
Right. So being separated doesn't necessarily mean you live in 2 separate residences. And so how do we define separation? It could be living in 2 different rooms. It could be not sharing the same bed anymore. It could sort of go into a very uncomfortable conversation with your client about when marital relations ceased. And all of these things are clues that the court has in terms of when did the marriage irretrievably break down.
Well, what if something happens during that time period because, you've been married to this person for so long, and if one side really doesn't want this divorce and, they reconnect.
Going on?
Yeah, they reconnect and this 6-month or 2-year period has not elapsed. Is that now, does that start the clock over?
So you bring up a really good point. In terms of the 2 years, that can be waived. And I want our viewers to understand, if both parties agree, you can waive the 2-year requirement. However, when it comes to the minimum of 6 months, judges hold that very strictly, and they will actually count. Whatever you testify as the day of separation, they will make sure 6 months have passed, or they will deny you your divorce that day in court.
But when you're talking about testifying to separation, are people answering the question, when did the separation start?
Exactly.
Or does it include, the separation originally started on this date, but then 3 months later, we restarted this relationship.
But then you're not separated anymore.
Okay,
if you
so
had
that
reconciled, it would start the clock over.
Okay.
But the issue is both parties have to agree in terms of the date of separation.
Oh,
and
really? So
if
someone says, oh, no, we started, this separation started.
So that's where
then you're going to trial.
When one party says, no, that glass of wine and what happened after was not a reconciliation. I didn't mean it.
So when I say it boils down to testimony, it really does. And the
Wow.
judge has to think about who's most credible. And really, most of the time the parties can say, well, I think it was on or about December 1st. And maybe, if there's a 2-week period that people are kind of sort of in agreement on, then the courts will be more than happy to just use that time frame.
So it's 6 months no matter what, and you can't prevent the divorce.
Now, one thing I do want to mention is that the Illinois Dissolution of Marriage Act is going to be amended. We're going to have some new laws in place in 2016, and this is really exciting and extremely concerning to divorce attorneys because so much is going to change. But I bring that up because I want everyone to understand that this particular law about the amount of time required for separation is also going to be changed. So hopefully we'll have more news for you in the near future.
So what's the new protocol going to be?
My understanding is that they're going to get rid of it entirely. So if I want to get divorced tomorrow, maybe I'll be able to go fill out the paperwork and get divorced in a matter of days as soon as the judge has time.
Wow.
Which would be really different.
That's really interesting.
Is our jurisdiction the common situation where it's a no-fault?
Exactly. I want to say it was in the early 80s, and don't quote me on that because I have to refresh my recollection. But around that time, late 70s, early 80s, is when a lot of the states decided that they were going to follow a no-fault route.
And so anyone who wants a divorce can get it.
We're not going to hold you to your spouse anymore.
Well, what can you do? What can you do? Well, anyway, thank you so much, Ish, for bringing us up to speed on new developments, and we'll be right back. Thanks. Welcome back to Bar Talk. So I want to talk to everybody about some interesting news coming out of Elkhart, Indiana. Apparently, putting baby Jesus in the Christmas play is offensive to the atheists. What do you ladies think?
Wait a minute. Are they just taking the baby out and leaving everything else?
They're getting rid of all religion. They're saying separation of church and state, and it's improper to include baby Jesus in the Christmas play in a public school. So I thought that was really interesting when I was looking at it because this is something that comes up in holiday times when we want to put the kids in the play or the holiday presentation for parents and the schools, and baby Jesus had a place and maybe not so more. So
Okay,
what do you think?
just so that I'm straight on the situation, there's a play and students are participating in these roles, or this is a display?
Well, right. So there's a school play, and the atheists who are from the Freedom from Religion Foundation, which is comprised of atheists and agnostics. It's a nationwide group. They have filed a federal lawsuit in the Northern District of Indiana Federal Court alleging a case upon an unnamed student who's a performer in the Christmas Spectacular and saying that it violates his right to be free from religion in a public school and that the placement of Jesus in the holiday play is a violation of his rights as an atheist.
Well, I will say I have seen more and more school districts heading in the direction.
Wait a minute. It's a violation of whose right? Does he have to see it?
He's in it.
Does he have to be in it?
Well, he doesn't have to, but
But he's still exposed to it. I mean,
he's
if that's not your belief system, and if these aren't characters that you really want to be emulating as part of your life, why would you want to see your classmates and
But
have
do
the
you
entire
have to be
focus
in
of the
it?
school be focused on something
Because
that maybe
shouldn't
you
we
object
respect other cultures, other religions, other beliefs?
this is the problem because it's public school. So here it shows under the Indiana Constitution, as well as it's mirrored in other state constitutions, that it's illegal for a public school to endorse religion to students by organizing a religious performance, such as acting out the exclusively Christian legend of Jesus' birth.
Well, because imagine if it were a Muslim holiday. Would you really want your children, if they were not Muslim themselves, to feel like they were maybe pressured or encouraged or maybe even made to just watch a performance that didn't really reflect
I think
their
it
belief
hinges
system?
for me on whether they are required or whether it's elective.
But
for
even
me,
if
that
it's
makes
elective,
a big
you're
difference.
picking one religion out of how many in the world, and you're not representing all of them equally. So is that really fair?
They're making it a Christmas pageant rather than a holiday, a holiday show or...
But that's the nature of education. We always have to pick and choose what we're going to teach our children because we don't have the time to teach all of the things that you can learn historically on the global basis, on all the issues, on geography. Now, if you have a concern about focusing on one type of religion. I think the answer can be solved by, doing some sort of alternating, but I think there's processes and communication that you can have that address the concern. I don't think that forbidding the practice is the answer. I think that's going in the wrong direction.
What about school prayer? They used to make everyone pray in the morning in public schools.
Again, it hinges for me on whether it's elective or whether it's required.
But the thing is that if you're having a Christian celebration in a public school, all of those who are Christian themselves, especially younger students as well as their parents, would probably gravitate toward that because that aligns with their faith. But implicitly it excludes people who celebrate Kwanzaa, people who are Muslim, people who are Jewish. If you're going to have a Christian Christmas celebration, Christmas is technically a Christian concept. And if you're not a Christian, then you're completely excluded because you don't believe in that. So
I don't think Christmas needs to be part of the school system. I understand that maybe there should be some education centered around different holidays celebrated in all different religions. But in terms of what happens around December 25th in our public school system, I don't think it should be celebrated. I don't think that the children need to be exposed to it at that time because it could be viewed as some type of endorsement.
Well, what's interesting about the article is it says the lawsuit was filled with all sorts of damning evidence, including accusations that young people sang songs like Joy to the World and Silent Night. The investigation uncovered appearances by the Virgin Mary, shepherds, and biblical figures. So they characterize
Sounds dangerous.
It sounds so dangerous, and it sounds like anyone. They said it would curl the toes of the average atheist. So I think it's a little bit sensationalized, but I think if you take it down to its kind of lowest common denominator, there's something to be said for Dana's point that if the child is, if everybody in Mrs. Gardner's third grade class is putting on the play, then, maybe it is something that's a little bit compulsory. And if someone who's not a member of the Christian faith were chosen to represent Christian values that they themselves or their families didn't hold, it would be an issue. But, I think it depends on whether we're going to revere Christianity as the one and only belief system. And if you're putting on a Christmas play, that implicitly excludes everybody else.
I feel bad for atheists. I think it's a tough country to live in if you don't follow the belief system of the majority.
Oh, well, ladies, that's one for another day and perhaps a bottle of wine. But anyway, thank you for joining us on our discussion this evening, and we'll be right back. Thanks so much. Welcome back. We're going to be talking about wrongful termination cases settled by Cook County. $90,000 on the price tag. Was it a good idea? So, ladies, do you think political cases, when somebody sues the city, is it a good idea for the city, right or wrong, good or bad, to write the check?
Well, whose side are you on?
I don't know. See, I happen to represent a client right now that has a beef with the city of Chicago, so I think that, in the case that I'm advancing, we want to take it to trial. And
I
if
think
it settles,
the personal
it better be the
relations
right amount.
director for the city of Chicago would say it's probably in their best interest to settle this, keep this quiet. I mean, I think
Right, you don't want all that dirty laundry out on the table.
I think that's common practice. You can assess what you save by quieting this quickly,
Right.
and moving on with it.
But I think from a plaintiff's perspective, what I always disagree with in those settlements is the language that says they don't accept any wrongdoing. Mm-hmm. And to me, it's almost like a slap in the face because the entire point we are in court to begin with is because someone was wronged here.
Well, not only that, they have settlement and confidentiality provisions that the parties can't talk about it. So which is attended to most cases and how things get settled.
But that seems reasonable. I mean, what would you want in exchange for not going through the process?
How about an apology? Is that too much to ask for?
That's actually not uncommon.
But
right.
Yeah, but I think it is a very fine line that you have to consider. If you're stating an apology and you're not wanting to express any fault because maybe you weren't at fault. That's the point. You're not willing to drag this out, spend a lot of money on this process.
Right.
So you bring up an important point. You're saying that guilty or innocent, settling could be in your best interest either way.
Sure.
Well, anytime you have a case in court, the client, whoever they are, the plaintiff and the defendant, really have to examine the costs. Between day one and day of trial, that could be years in the making. So there are a lot of legal bills that are going back and forth and a lot of expenses being advanced to pursue the litigation. And so from the city perspective, they've got taxpayer funds, they've got pressure from many departments and possibly government top-down examination to look at whether or not the case is viable.
I suspect that these decisions to settle hinge on economics. I don't think that they're really necessarily on either side considering so much the principle of the merit of the issue of the case. How's it going to impact?
I think that they could, though. I think from a political perspective, you might be worried that it will change the constituents' opinion of you.
Oh, I absolutely agree with that. So I wasn't thinking along those lines, but I was thinking from the standpoint, particularly of the plaintiff who feels wronged. Maybe they haven't been wronged, we don't know, but they feel wronged. So now they want to expose this.
Right.
And so there is something driving them, and it may not be necessarily monetary, this driving force.
Principle. They
right.
want to be right.
But ultimately, the decision when settlement talks begin, you start to discuss, like you said, the first thing you talk about is how long is this going to take? How much is this going to cost?
Right.
And I think that the decision is typically going to be based economically.
Well, and I think it also goes to whether the type of case. If you're a plaintiff and you're paying your lawyer by the hour and you're writing checks every month, your ability to fund and bear the freight of the weight of the case is going to make a difference there. So a lot of times plaintiffs will settle because they're in a position where they're bleeding. And especially if you're suing a municipality, they've oftentimes got teams of lawyers. I represented a client and we sued the Board of Education of the City of Chicago, and they had 16 lawyers against me. And they tried to bury me. And my client had a very difficult time advancing the money for the case. So sometimes the plaintiff is going to look to settle with the municipality because they have difficulty.
And sometimes they're going to reject that settlement. I actually just read a case, I believe it was in New Jersey, where the police department offered to settle a matter where a young African-American male was killed without justification. And they wanted to settle, and the mother of this child refused because she did not want money. As you were stating, it wasn't her goal, and she wanted to be able to speak publicly about this, and she was not going to accept any kind of settlement. That quieted her voice, and that imposed a gag order on the very issue that she feels still has a huge impact for our nation.
Well, and those are so emotional, but oftentimes it's the number's not right. If you have a case that the plaintiff thinks is worth $500,000 or, a severed arm or an injury or a death, that has value. And when people in the media see high-profile cases getting big payouts, they say to themselves, well, why isn't my case worthy? If, you have a $7,000 offer and your plaintiff thinks it's worth, north of six figures, that's an issue. And that's what a lot of lawyers have to do. We have to discuss with our clients what are the economics, what are the issues that are going to come up at trial, what are the things that the plaintiff has to consider.
Well, what about the public good? Isn't that something the plaintiff should consider? That
Absolutely.
Maybe by settling, there's more change that is going to be suppressed going forward, and politicians and municipalities might feel like they can treat people.
Well, I think sometimes people
recourse.
can feel that they are limited in fighting an establishment. You've got the David and Goliath issue,
yeah.
and then you've got the financial aspect of it. But I'm not sure that people realize that sometimes if an issue is very important to the public, it's obviously important to the plaintiff, but if it's also something that resonates with the public, there is help. There can be attorneys out there who want to take that case on a pro bono basis,
right.
because it's an issue that for them, whether it resonates with them personally, whether professionally,
right.
it's something that can assist them.
Listen, we're out of time, but let's talk more about this on another time. Thank you so much for joining us. This has been Bar Talk.
Thanks for joining us back on Bar Talk. We're here at Levin Law Office. Thank you, Elisa, for letting us tape the show.
You're very
Your
welcome.
office is a great spot.
Thank you.
Gorgeous.
How are you ladies doing?
Doing really good. How are you?
I'm good. Did you catch any of the Cubs game? Go Cubs. They won yesterday.
So far, so good. We'll see.
Yeah. We're very superstitious here in Chicago, so this might be the year. There's a Back to the Future reference. 2015, They're going to win the World Series.
I was going to say, I've heard this is going to be the year a few times. So.
Well, this is going to be the
I hear
year.
that
It's
every
in the
year,
see the fingernail? It's in the nails. So tonight we're going to talk about the grandparents, whether they have any rights to visitation. We're going to talk about appealing judgments and whether you can stop enforceability. We have a special guest for you, Lisa Lilly. She is a lawyer who is also a published author. And we have a controversial hot topic, and I'll save that for a little bit later. So, Ish, I want to know about grandparents and whether they have any rights to see their grandchildren.
That's a really good question. I think the best way to summarize it for our viewers is that grandparents do not have a right, but they might have a privilege.
Okay.
And so what the best option for them would be to petition the court and see if the court is going to grant them visitation with their grandchildren.
Well, I've thought about this issue several times since I had my own kids, and I've found myself going back and forth. As a parent, if I didn't want my children to see their grandparents for whatever reason, maybe I feel that the grandparents are not a good influence. And do I have the right as the parent to stop that from happening?
I mean, you bring up a really good question because a lot of people have framed this as a constitutional issue. Parents constitutionally have the right to raise their children as they see fit. And so the courts are not able to override that right without doing so in the best interest of the children.
So if the best interest of the child standard is employed in evaluating any kind of petition that's filed, is it incumbent upon the grandparent to establish that involvement in the child's life is in fact in the child's best interest?
Exactly. And if we had a situation, taking Dana for example, if the mother says, I do not want this to be allowed, I do not want my children to have visitation with this particular set of grandparents, then the mother's wishes should really be controlling. The only way a grandparent could get around that is if they could prove that it would actually harm the children to refuse them visitation.
Well, harming children is going to go back to, I have this bond with this child, and this is a loving bond that is
Are you
going
speaking as a mother or as a grandparent?
No, I'm speaking as the grandparent who's now trying to overcome that issue by saying that there is going to be harm caused to this child because we have a bond, and I nurture this child. And I want to develop this bond. I mean, are those the sorts of arguments that the grandparent would present?
Exactly. It's going to be very fact specific. The grandparents have a much better chance if perhaps their child, the grandchild's parent, right, is maybe incarcerated, or maybe if they're recently deceased, and if the grandparents can show that without court intervention, they're going to be cut off from what could be a very loving and nurturing relationship with these grandchildren.
When the children are old enough to express their opinions, does that matter?
That's what I was going to ask.
It really doesn't. Courts do not like to put children in the middle of what's essentially a custody battle. I mean, it's simply visitation, but you're really creating the ability for children to maintain a relationship with these other individuals. And to be honest, that's not always going to happen.
Would the child have a converse ability to file a petition if they were prevented from seeing their grandparent? Would the child have is there an avenue for the kid to say, I want to establish visitation with grandma or grandpa?
The child does not have standing on its own, but perhaps someone could file on the child's behalf.
Because they're not yet 18,
Correct.
so they need an advocate for them.
A friend of the child could easily file on
Oh, so
their
it doesn't even have to be the parent.
Well, you have to have standing, right? So if the child is the one who is advocating for visitation, they would need an adult to step in and file the petition on their behalf.
So this can be an
Well,
aunt?
Is that when it's called next friend of so-and-so?
Correct, but the
Okay.
courts do not have to grant this petition. The courts might say, well, you as a child, you have no rights. This is a parent matter. It's your parents who get to decide who you see and who you spend your time with. As a country, we do not give that ability to children.
So how does this tie into the child being able to be emancipated? If there's a proceeding to emancipate and to be able to give children, or at least someone under the age of majority, so under the age of 18, rights to make decisions, how can those two kind of situations, how do they work together?
I think you bring up an important point. You have to be emancipated to have that much control over your life. And if you are still a minor...
Well, this is a great topic, and I think we could go in a lot of directions with it, and I think it's really, relatable for a lot of our viewers, but we have to go to break. We'll be right back. Welcome back to Bar Talk. We're going to talk about the enforceability of judgments next. And Elisa, I have questions for you about this.
What do you want to know?
Well, if someone has a judgment against them and it's now enforceable. Can they prevent this from being enforced against them?
They can. So it depends a little bit on whether or not there's going to be an appeal of the judgment, but there is such a thing as called a stay of enforcement of judgments, and that is when you get a bond or you get a security put up before the court. So it could be an insurance policy, it could be a cash bond, or it could be collateral that protects the judgment creditor. So generally speaking, the way that it works is if people want to stop enforcement very often when they are on appeal because they are asking a higher court to reverse the judgment against them. So for example, if you have a $10,000 judgment against you, you would have to come up with $15,000 worth of something to satisfy a court that that is a good security in order to prevent enforcement of judgment. So what a lot of people don't know is that if they're faced with a judgment and they're planning to attack it, in the meantime, their bank accounts can be frozen, citations to discover assets can issue, and a lot of court proceedings can be happening.
That's what's interesting to me, because I would think that if your case is not finally settled because you've got a pending appeal, that you are not expecting this judgment to be attached and to be assessed against you.
Exactly right. That's the issue, is that I did a blog post on this recently as a result of some issues that I'm facing in my practice. Clients don't know that the end of the case doesn't mean, the end of the case meaning what's happening on appeal. They're waiting for those things, briefs to be written and decisions made by the higher court. They think, well, if it's not over yet, that, I don't have to worry about it. But in fact, the minute the judgment is entered, a sophisticated creditor attorney will be already planning on garnishing wages from your employer, which is 15% of your income. They will be looking at where you bank.
But that makes sense to me. I have to say, it's a judgment,
absolutely.
And it's valid, so of course there's going to be consequences.
But that's the point, is that a defense attorney has to have a discussion with the client, not only about appellate rights and how they can protect their interest in the case going forward to preserve and create a record for appealability purposes. They also have to talk about asset protection so they can get the bond. You can also request personal exemptions are available under Illinois and most state laws that say there's a list of things that are exempt, including pensions, child support. There's a wild card exemption for $4,000 of personal property.
So if we go through these steps, let's say the judgment is enforced against you, they freeze your account, they withdraw that money to pay the judgment, then you go to appeal.
Well, you've skipped a step. So what happens is when a citation to discover assets is filed, it's a separate proceeding, kind of a separate case that goes on the same case number. So when the bank account is frozen, that is because a third-party citation to discover assets was filed. So that's a piece of paper that's sent to, say, Chase Bank that says, hey, Chase, I think you have some money belonging to my debtor over there. Tell me what money you have. And then when Chase Bank writes back and says, well, we have $5,000.
Does Chase Bank have to tell you that they told...
that they received the citation?
As a matter of good business, they usually do, but no, they are not required. The creditor has to notify the debtor.
The creditor has to let...
3 days after the bank or the other third party receives the notice. So the creditor is given a head start to get the money, to do the freeze before the debtor even knows. Once the citation respondent, the bank, has answered, the debtor is made aware of it, and then at that point is when it's the debtor's responsibility to file a motion to quash or a motion to assert exemption.
And so this is how you stop it from happening.
This is how you stop it, because if you just stand by
in.
and say, they're taking all my money for child support, and you just say that orally in court, that may not be enough. You have to assert an official exemption. So you have to file on your own.
So you actually can't stop the citation from being issued.
The citation is issued, but the citation proceeding is not what transfers the money. All the citation does is tell the third party or anyone who's the respondent in the citation.
It gives them the information.
Stop. Hold the money. Hold the asset. Don't do anything until further notice. The creditor files a motion for turnover. So it's a secondary order that a judge is entering that says, okay, third party, you are now under the jurisdiction of the court. You have to write
You
that
know, I
check.
have to say, I've always heard collecting on a judgment is a lot of work and it takes a lot of time and effort, and now I see why.
It's multiple proceedings, multiple motions. It's crazy. And I'll say that very aggressive.
Would that be a legal term, Elisa?
That's crazy.
Crazy and chutzpah and phooey have definitely been advanced.
Just a quick
on behalf
question
of my
before we
clients.
wrap up this topic was, after that money is taken out and it goes to the issue goes to appeal, and let's say you win, so the money has to be returned to you?
Yes.
Is it automatic?
No. You would have to request as part of the appellate proceedings, depending on how they remand it back to the circuit court.
So do you have to go through collection procedures,
You very
take
well-
all these steps to get your money back?
You very well could. It
Oh, wow.
depends on dissipation of assets. So, lawyers and people involved in lawsuits would be advised to see these steps ahead for the future.
Okay.
Great
Well,
information.
yeah, thanks for that information.
You're welcome.
We'll be right back. Thanks for joining us. We are here now with Lisa Lilly. She's an attorney who has become a published author. She has 2 books that are part of a series that are very interesting. We're going to talk to her about that. We're also going to talk to her a little bit about her background and how she made that transition. Lisa, welcome to the show.
Thank you. It's great to be here.
Yeah, we really enjoy and appreciate you coming out to tell us about your story and all of these. These I know you have some interesting stuff to share with us, so we're going to get right into it. Why don't you start by just giving our viewers some background on your experience as a lawyer, what kind of work you did, and what kind of prompted you into writing?
Well, as a lawyer, I mainly handled appellate work and commercial litigation and class actions, which involves a lot of writing, which is part of why I was drawn to that practice area. I wrote since I was a kid, and I wrote for many years between college and law school and was not making any money at it, at fiction writing, until I became a lawyer, and then being able to write creatively was very helpful. So it is something I was always juggling and struggling to carve out time for, and I've been very happy that in the last year I've shifted over so that most of my professional life is spent writing now.
So do you still practice law?
I do practice. I have a few cases for some good clients that I am going to finish out for them. And I do some work with a nonprofit, the Alliance Against Intoxicated Motorists, so I offer advice to some of the people that
sounds busy.
meet me. Yes, it is pretty busy, but
So did you spend a lot of time in court when you were handling your cases, or is this a lot of desk work?
It's more desk work than, I had a colleague I shared space with who was a trial lawyer, and he'd say, oh, you get paid to type. I want to get paid to type. I'm like, really? It's not for my typing speed. But I would be in court. I did a lot of substantive motions, so summary judgment, class actions, appellate arguments, not very many trials because the cases are so huge that quite often they resolve before that time.
With settlement, we know a little bit about that.
That's right. Or if it isn't a class, then it
Yeah.
tends to just go away.
Yeah, and so does your skills that you developed as a lawyer, do you find that any of that is helpful in writing? Do you translate any of those skills over?
Yeah, I feel like it's been a huge help to me. Both have helped the other. Certainly being a good writer helped me a lot in law school, even though legal writing is a whole different animal. It helped to have those writing skills. And being a lawyer, for one thing, you learn to write on a deadline because a brief is due when it's due, so you don't wait till you feel like writing it. And I feel like that has helped me. I have never had trouble sitting down. When I first draft a novel, I set a schedule, I write a certain number of words a day, and I just do that just like I would write.
So it's
legal
trained
writing.
you in a lot of discipline.
Yes, it's the discipline, the precision with language, and also I think the ability to see different points of view, which you always have to do in litigation, and I feel like that is a huge part of fiction.
Well, sure,
writing.
because when you're writing, right, you are now developing all of these characters and points of view, and I didn't really think about that until you just said this, because when I'm reading, it's just all nicely laid out for me, so it's easy to adopt, but from the other side of it, when you're putting it together and really trying to make those perspectives clear, I can see how that would translate then. to help you do that?
Yeah, my favorite kind of villain in books that I read as well is the one that you really empathize with. I mean, nobody believes that they are at heart a bad person. And so when you are writing that point of view, you have to be able to get into that, whether it's a person or, some sort of conspiracy group or whatever it is. They don't think that they're evil. They think that they have important aims they're trying to achieve.
Well, I have your book here, The Awakening.
Yes.
I want you, if you would, please, don't give it away. Don't give away the good stuff. But if you could give me just a basic synopsis, because the cover page is pretty interesting here. We have a girl, I don't know if the viewers can see this, but we have a girl who's pregnant, and she's cradling the bottom of her stomach. But she's in this red moon that looks sort of like it's eclipsing.
Yes, there is. I won't spoil anything, but there is an eclipse that features in it. You can kind of tell one of my favorite books was Rosemary's Baby. This is a little bit different, but it is about a young woman who goes on the run because a fringe religious group believes that she and her child are going to trigger the apocalypse. Wow. So this is book 1 of the series. Book 2, The Unbelievers, came out last year, and I'm working on the 3rd book. So it's a 4-book series.
Oh, that's
very
great.
exciting.
And where could we get The Awakening?
You can find it either on Amazon or barnesandnoble.com, or you can go into Barnes & Noble. If it's not there, they can order it for you.
Okay.
And it's available in Kindle, Nook, paperback, audio. If people have an ACX Audible subscription, they can get it on Audible as well.
That's good to know as well. You had mentioned, I just want to touch briefly, that you do some work with a local Illinois organization, Alliance Against Intoxicated Motorists.
Yes, it's AIM. It's an Illinois nonprofit aimed at preventing DUIs.
And your work there is about publicly informing and outreaching?
Yeah, helping educate people about the dangers of DUI, because my parents were killed by an intoxicated driver in 2007. That's how I got involved.
Okay.
Wow, so you have your hands in so many different projects.
Yes.
That's got to keep you busy.
It does, and it keeps life interesting.
And kudos to you to do all of this at the same time and still find time to be involved in that organization, because that's an important one.
Thanks for sharing with us.
Thanks for joining us. Thank you. We will be right back. We're back, and we are going to talk about our hot topic tonight. We have a new law in California. I don't know if you ladies have heard about it. I think it's a big deal. I think that this could mean major repercussions for other states if they follow through, and I think there's going to be a lot of controversy. So the issue here is that California has now permitted people to make a decision when and how they would like to die if they have a terminal illness, and they can now make arrangements to take lethal medication.
I think it's fantastic. Jack Kevorkian, for many years, had a lot of legal troubles as a physician trying to assist patients with end-of-life issues. And Brittany Maynard...
Is Dr. Kevorkian still alive?
I'm not.
No,
I'm not really sure. Okay,
passed a few years ago.
But Brittany Maynard, the woman who kind of spearheaded this recent movement, specifically moved to Oregon in the face of a brain cancer diagnosis because she wanted to control the manner of her death. And through Facebook and social media, really put it out there that this was very important to her. And it was awesome, because I think at the point in time when you have multiple physicians saying that the end of life is near, and you have the right as a patient, as long as you're lucid, to control pain and to control end-of-life issues by way of an advance directive.
Right, but there's a difference between controlling end of life and actually terminating life.
Well,
and I think that's what crosses the line here. Physicians are under an oath to do no harm. And regardless of a patient's wishes, I'm not sure that it's so clear that it's always in their best interest to permit them to terminate early a life that perhaps hasn't been lived to the degree that it could.
Well, I think it also easily begs the question is whether this person has capacity at the time, at the end, because maybe they made this decision when they did have capacity, and that could be shown or proven or at least believed. But you should have the ability to change your mind, and maybe you're not in the right state of mind to change your mind at that time. And so I guess I'm pointing to the risks involved in allowing this, and I am concerned. While I do agree that people should be allowed to die with dignity, I'm not sure that we can have a mechanism to sufficiently mitigate those risks.
Well, I think it goes also whether or not you agree that suicide should be legal or illegal. A lot of states have books or laws on the books that go to suicide being illegal. Personally, I think that if you would like to end your life at any stage in your life, you have the right to do that.
But you bring up a good question. Does the Constitution speak to this very particular issue?
It doesn't, and I think that's what creates all of the gray area in the law, is that you have a right to life, but do you have a mandate to keep life, to preserve life? And that goes to the Hippocratic Oath that you're talking about with physicians that do no harm. But at a certain point, if you have a neuroblastoma, you've got brain cancer, you have something that's causing you so much pain, how can a doctor say to you that keeping you alive is doing no harm?
But wait a minute.
It's a personal decision.
There isn't just one option here. I'm sure all of you are aware that there are hospice and palliative care groups, and their entire goal is to assist a patient to die with dignity, but they do not hasten death and they do not slow it down.
But dying with dignity has different meanings to different people. I think dying with dignity is my clothes on. I don't know that dying with dignity is necessarily pain-free or not pain-free. I think that, and you have people with different thresholds, different ideas of dignity. To me, dying with dignity is dying how I choose. So I think it depends on what the palliative care and the hospice, what do they mean by that?
But let's get back to the risks, because we're not touching upon the real potential, the risk to the person who is dying, the risk of undue influence, the risk of...
So they do try to mitigate some of this. My understanding is that your first doctor writes the prescription and a second doctor has to also concur with the diagnosis, meaning that you are competent to make this decision. There is also a waiting period, I understand, of a period of at least 15 days or a few weeks, in which you could change your mind if needed.
So they have thought of all these different processes, and there's 12 or 15 different check marks that they have to put down in order to satisfy all of that. But we live in an imperfect procedural society. In no place do you have procedure which works seamlessly. And the problem with this issue is that the crux of it is someone's life. I mean, it is the most valuable, it's the most valuable thing you have.
But it's their life making their decision. If you're talking...
You hope, but that's not the risk. We're allowing, and I think most people do agree that people should be able to decide. I don't think that's where the controversy is. I think the controversy is this going to have unintended consequences where what we want to happen is not going to happen?
Well, the road to hell is paved with good intentions, so I think there's always the risk of having mistakes and undue influence, but we have to work toward giving people the right to make their
I don't know if I want to say the road to hell or the road to heaven under the circumstances of our discussion.
It depends if you're religious or not. So
Right, and I think it is a moral issue. I mean, we can't skirt around that a lot of religions forbid this type of thing from happening, and now as a country we're sanctioning it.
Ladies, the debate will go on, and I'm interested to see what happens, and I hope that things work out with good...
Well, 1 in 10 Americans is from California, is my understanding, so what happened there is really going to affect the rest of us.
Thanks for joining us tonight. We hope you enjoyed the show. If you have anything you'd like to tell us, we'd love to hear about it. So find us on Facebook, and we'll hope to hear from you soon. Good night.